Thank you, Chairman Grassley, and thank you to each of the panelists for coming here today and testifying on this important issue. It is particularly valuable that you're here to shed light on two issues important to our nation, to our families, and frankly also to my home state of Delaware, namely bankruptcy and data privacy. As I'm sure some of you know, Delaware is the most popular state in our nation for corporate incorporation, which also makes it a prominent bankruptcy jurisdiction. Delaware also is one of a small handful of states that's enacted robust data privacy protection laws, making it a potential model for federal legislation on data privacy, particularly in the context of bankruptcy. I do think it's critical that we strike the right balance between safeguarding data and personal information and maintaining a bankruptcy system that makes creditors whole and gives debtors a fresh start. If I might, Professor Gottberg, is a prospective buyer in bankruptcy legally required to follow 23andMe's current privacy policy?
So the privacy policy is a contract.
Right.
So contracts are enforceable as between the two parties. In law school, we like to teach that a contract is a promise to perform or to pay damages. So a company that undertakes a contract, if they don't perform, would open itself up to a lawsuit for damages. That's true for 23andMe, and it would be true for any subsequent buyer. Whatever the subsequent buyer agreed to do would just be a contract. There would be no enforcement mechanism to force them to comply. They could just choose to breach.
Nothing other than damages enforces that contract. And is there anything in the bankruptcy code that specifically addresses the transfer and use of highly sensitive personal data?
In that situation, that is where the consumer privacy ombudsman could be appointed.
Could be.
Right. But in that situation, their role is primarily to advise the bankruptcy judge to weigh the costs and benefits of any potential breach of a privacy policy. So again, without being able to put a number on what those damages are, what the cost is for a violation of privacy, it actually becomes a pretty difficult weighing exercise.
Is there any relevant precedent?
I don't know that it's ever been litigated. I haven't seen anything.
Me neither. Professor Cohen, Delaware and a few other states have enacted strong data privacy laws designed to regulate entities that control sensitive data, give individual consumers the right to access, correct, or delete certain data. How can my colleagues and I do something similar at the federal level, and specifically in the bankruptcy context, to ensure sensitive data doesn't end up in the hands of the wrong people or the wrong country as a result of a bankruptcy proceeding? And what's your view on the Don't Sell My Data Act, where I've joined Senators Grassley, Cornyn, and Klobuchar as a co-sponsor?
So I think the Don't Sell My Data Act is exactly the right idea here. I will say that I think that what's important is this idea of affirmative consent. That's what's central to the bill upon the transfer. And again, we still really haven't heard a good reason why we can't go back to all of these people and ask them, can you affirmatively consent to the transfer of your data to Regeneron or TTAM? So I'd love to see Congress push that and push it beyond bankruptcy to other kinds of sales of information as well.
Let me ask you a question about affirmative consent. Part of the market value of 23andMe is a service that is individually genetically identifying, that gives you information about, honestly, one of the most private things there could be, which is whether or not you're susceptible to certain diseases, what's your genetic ancestry, that sort of thing. Would it not stand to reason that although logistically challenging, going back to every individual who's given their personally identifying genetic information to 23andMe and affirming their consent would actually, in the end, build their market value by reinforcing that this kind of a service is something where people can count on it to protect their data privacy, regardless of whether there are damages available?
I think if you build your company on a reputation of trust and a reputation of autonomy and empowering people, this is exactly the thing you want to sell to customers, to say, we believe so much in what we say that we're even going to do this upon sale or bankruptcy.
I mean, I understand how it might be complex or expensive, but in the end, I think it ultimately serves the entire segment of personally identifying genetic consult because it builds trust. Thank you, Mr. Chairman. Thanks for a chance to question witnesses.
Yeah. I'll take my turn now. I'm going to start with Mr. Savage. In 23andMe's March 20